been a
And then he's like, all right, it's not going to be fixed for a couple of weeks. You've got 3 compressors now in the unit. They just can't get this. It's just a
Thankfully, it's Jack.
That guy's never attended a grievance meeting nor an ethics meeting. Oh, yeah. Hey, how are you? Good to see you, John. Oh, no.
I was not that cool. I never met all of them on that class for hours. Yeah. You baked yeah. It's like
You want me to? No, I do not. Start feeding. Yeah, exactly.
I don't like that. I don't have any emails that say not going to use no, Christmas. We've all for decorations.
Sydney.
The only things I'd like to I don't know what it's all. I'd like to do that. It's too close to Christmas. Yeah. And yeah. Thank you. You're exactly right. There you go again. Yes, thank you. I appreciate it.
I have asked so many times.
Good morning, everyone. We are going to get started with our April Ethics Committee meeting. I want to welcome everybody back. And this room will get a little warm as the day goes on, so we are the lucky ones to be here first thing in the morning as opposed to later in the day. Yes, they'll keep those curtains closed so that the sun won't come through. But welcome again, and welcome to our guests that are here this morning. All right, we got everybody sitting. I'm sorry. Wait for Heidi. All right, so I'm going to start with our Ethics Act statement. Members of the committee are hereby advised of their duty under the state government's Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. So if you do have a conflict that you are aware of at this time, if you could just let us know, and if you realize later that you have a conflict, let us know at that time. All right, and so we're going to go down. Yes.
Could you move the microphone closer to your mouth or something? We can't hear you.
You can't hear me?
Old people in the back can.
Oh, okay, I got you.
See if that works.
All righty. Is that better? Maybe, no?
I apologize. All right, so you got Damon. Damon,
Is it on?
does the
Is
microphone
this thing on?
cause any static for our live stream?
Well, I think it was just static.
Okay. Just the breathing. Okay. All right, we're gonna get it. Damon
Y'all
makes
need
everything
mine.
work.
So I need to use my screaming and my teenage voice upstairs. Okay, all right. So we are going to go through our agenda as printed, and we will start with administrative matters, report on trust account audits. Yeah. Hello. Hello.
Can y'all hear me or do I need a microphone?
Oh, they got one down there.
Okay. Sorry, that means I'm gonna have to look down. Can anybody hear me now? Okay. So audits for the first quarter were conducted in Durham, Granville, Lee, Mecklenburg, Pasquotank, and Wake counties. One audit was conducted in Granville. 2 audits each were conducted in Lee and Pasquotank. 5 audits each were conducted in Durham and Mecklenburg, and 8 audits were conducted in Wake. The 2 most common rule violations were that 43% failed to review bank statements and cancel checks each month, or make a report that they did so, and 39% failed to complete quarterly transaction reviews. Based on the 2025 geographic plan, audits for the second quarter will be in Bertie, Cumberland, Henderson, Buncombe, Durham, Hope, Carteret, Forsyth, Mecklenburg, Craven, Franklin, Pitt, and Wake counties. Any questions?
Have a good meeting. Thank you, Andy. All right, next we will have report on ethics phone calls during the prior quarter. Suzanne.
That's me. Can you hear me? Last quarter, we answered 1,153 ethics inquiries, so we were pretty busy. The top 3 for the last quarter were conflicts, always number 1, and then confidentiality and advertising. So pretty consistent on that front.
All right, any questions for Suzanne? All righty, moving right along. Report on CLE ethics presentations during the prior quarter. Brian.
All right, this is me. I'm not sure if I need this, but we'll just go ahead and use it. We did 7 CLE presentations over the past quarter. You'll note in the descriptions, 3 of the 7 concern artificial intelligence. I don't know what happened, but apparently everyone's interested in artificial intelligence these days. But nevertheless, we are here to give these different CLE presentations. We want to reiterate, if you have an organization, your district, whoever needs an ethics speaker, let us know. We have a number of presentations, or if you need something tailored for your particular group or particular issue that you're facing, let us know. We are happy to help out.
Any questions for Brian? All right. Keep it moving. We're going to our subcommittee reports, pending inquiries. Inquiry of Kemp Public Defender offices in a multi-county district. We'll start with our staff presentation by Nicole.
This is an inquiry that we received from Mr. Kemp asking about preparing an opinion that would allow public defenders' offices in a multi-county district to operate as their own separate law firms for purposes of avoiding conflicts of interest. The main concern was that in many counties in North Carolina, there are not enough lawyers on the court-appointed list. There are not enough lawyers in the public sector to refer conflict cases out of the public defender's office. So I prepared an opinion that said, yes, we could do this, provided that there was separate leadership. No lawyer was involved in both cases where parties were adverse. So we're talking about co-defendants who were adverse to each other, or maybe a witness who was also a client of the public defender's office, and he was adverse to another defendant. So the subcommittee met and raised many concerns about the appearance of impropriety, the public not losing more trust in the public defender's office because they didn't feel that it was really a consentable kind of conflict where 2 defendants or a witness and a defendant could be opposed to each other, and the lawyers in the same office or under the same public defender represent them. They also raised concerns that even if each office could be separately staffed, there's only one public defender who was responsible for all of those client matters. Ellen Murphy informed us that in Wisconsin, they dealt with a similar issue. So I reached out to the Bar Council in Wisconsin to ask him about what happened in their district, or in their state rather. They decided that under their rules, co-defendants can't be represented by the same office, by the same public defender's office. They decided to change their rules to change that government lawyers don't include public defenders. And our subcommittee talked about that same issue, that public defenders represent people, whereas the district attorney represents the state. Or others like the AG represent state agencies. So they're not representing individuals, and therefore the public defender's office should be considered like a regular statewide law firm who represents people and apply Rule 1.10 on imputation of conflicts rather than Rule 1.11, which deals with conflicts with government lawyers. So Wisconsin decided that public defenders are not government lawyers, and they make changes to their rules accordingly. I passed that information on to Jay Vanoy, who was our chair. He isn't here today. And he directed me to set up a subcommittee meeting so that our subcommittee could look at whether or not we should change our rules to extract public defenders from Rule 1.11 and put them under Rule 1.10, imputation of conflict. So we have a subcommittee meeting set up for Monday, May 5th.
All right, thank you, Nicole. I'll start with hearing from Fran, one of our subcommittee members.
Good morning. As a former public defender, I asked to serve on the subcommittee because I felt so strongly about this proposed rule. At our meeting, we were joined by 2 acting chief public defenders, and there was really a consensus among committee members that, while we recognize that there are legal deserts out there that find an indigent defense counsel, it is a struggle when you've got multiple defendants, but that this rule is not the answer of putting public defenders in this position for all the reasons that Nicole has already explained. The appearance of impropriety. Public defenders already struggle with clients not thinking that they're real lawyers, and to put a client in that situation where they have to choose and make the decision whether or not to waive the conflict is unfair to pass that burden to clients that are sitting there with pending criminal charges and that need a lawyer. They're not in a position to make a good decision about that. The opinion talked about having distinct leadership. You can't have a distinct leadership because the chief public defender is the leader of both of those offices. Both chiefs expressed concerns about not being able to mentor these lawyers in their office that are struggling with these cases because they won't be able to come to them and talk about the cases. Odyssey was raised as an issue because even though it's 2 different public defender offices, they would have access to information about the other case. So again, there was just a consensus among the committee that this was just not the answer to dealing with lack of indigent defense counsel across the state.
Thank you, Fran. Any other members of the subcommittee want to speak on this? All right. I believe that, do we have a motion? I know you all have, there's a meeting set up for Monday. I believe we want send it back to the subcommittee, or keep it in subcommittee. All right.
Can I make that motion?
Yes.
I'll make that motion to keep it in the subcommittee for now.
Do I have a second?
Second.
All right, I have a proper motion and second to send this, return to subcommittee. All those in favor, please say aye.
Aye.
Any opposed, nay? All right, back to subcommittee. Thank you. Next, we have inquiry of DRC, negotiating licensor, reporting capability, doing mediation. Nicole.
So we've been talking about this one for a while, so I won't go into a whole lot of detail, but this is the opinion where lawyers participating at a mediation where they want to negotiate a term as part of the settlement agreement that no party or lawyer involved in the matter will report any lawyer to the North Carolina State Bar. And so we have a rule that's our opinion, ethics opinion, that you can't do that. You can't negotiate away the filing of a grievance. So we prepared an opinion that said the lawyer who is also the mediator who is also a lawyer has an obligation to avoid assisting in the violation of the rules of professional conduct. So it goes through several inquiries about what if they just communicated verbally, what if they just communicated in writing. The answer is all the same, no. The DRC looked at our opinion and was upset that we were telling lawyer mediators that they must withdraw from the mediation if the lawyers insist on negotiating this term, not to report another lawyer to the grievance committee. So they informed Brian of that. We talked to the subcommittee about it. The subcommittee said, mediators who are lawyers are lawyers. And under our preamble, you wear your lawyer hat all the time, and you're bound by the rules of professional conduct, and you can't assist other lawyers in violating the rules of professional conduct. So the subcommittee was reluctant and said, no, we are not going to change our opinion. We have the obligation and the authority to regulate lawyers, but we will let the DRC regulate the mediators, but any mediator who was also a lawyer is still governed by the rules of professional conduct. So we did not change our opinion and says that the lawyer must withdraw. The DRC issued their own advisory opinion that is really in line with our opinion and ultimately says that if the lawyer mediator learns of the term, that they should inform the lawyers that it might violate the rules of professional conduct, that they should seek ethics advice about that they can look at our opinion on it, and then if the lawyers insist on negotiating that term, then the lawyer mediator must withdraw from the representation. So the opinion, I think, is ready for publication, but I'll leave that up to David Allen to make that motion.
All right. David Allen, that's one of our subcommittee. Yes, sir.
One quick change in the course of the minutes that are the second thing in the packet. It says that we've got to discuss the inquiry of Kemp. We need to fix that just in the minutes, but that's just a typo that we need to fix. But Nicole is exactly right. We decided that we're very happy for the DRC to regulate conduct of mediators. They can tell mediators whatever they want to tell them. But that lawyers are lawyers all the time, and we will tell lawyers what they can do. You can't tell a non-lawyer mediator what they can do. And with all due respect to the DRC, we believe that lawyers will follow our dictates and our findings, and pretty resolute in our signals to the DRC. So I'm glad that they have understood our conversations. I know that staff has been pretty direct in communicating that at least there were immovable objects on our side, and said that this was what we were going to do, and I'm glad to know that they have gotten on board. So I think we are prepared, Madam Chairman, to recommend publication. I think is the proper step for us at this time, but I don't think it's been anywhere yet. So I move for publication.
All right. Do we have any other subcommittee members that would like to speak on this?
Dorothy, Wade Harrison, who is a certified mediator, was on our committee. Wade decided to choose to fly to Ireland today to be here. I sort of scolded him for his lack of dedication to Ireland. But told him that I would lift a pint in his honor if he would lift one in our honor. But he said he's a very veteran mediator, I think. He's fully on board where we are. I think the subcommittee's pretty unanimous on, not pretty unanimous, his unanimous position at where we are.
Well, I'm sure in Ireland he'll have plenty of opportunities to lift the pint. Do I have a second to that motion?
I'll second it.
All right, so we have a motion and proper second. Do we have any other discussion from anyone? All right, have a motion and a second to publish. All those in favor, please say aye.
Aye.
Any opposed, say nay. All right, we will publish. And then next, we will move on to inquiry of the grievance committee. Client consent to annual rate increase.
All right. So this is yes. This is an ethics opinion that came from grievance. This has been in our committee for a couple of quarters now, and we essentially have a situation where you've got a firm that has built into their fee agreement with a client a clause that permits the firm to increase their hourly rate, maybe periodically. I guess there's different variations of what the language can be. The variation that's articulated in the opinion basically allows the firm to increase their billing rate. They say they'll review it annually. They do not specify when exactly the increase will take place or what the increase will be, but that the client consents to it, and essentially when the firm does take a look at their fee agreement or their fees again on that annual basis, they simply change the fee, impose the fee, and bill the client for the work that's completed at the higher fee without any notice to the client other than being told at the outset of the representation, at some point we may increase our rate. And so the opinion essentially goes through the kind of the ethical considerations for whether or not a firm can have that type of clause in their fee agreement. Ultimately, the opinion does conclude that as drafted, the fee agreement clause that's presented, that's just kind of we're going to take a look at it, we'll increase it, we'll let you know after the increase has taken place and without any sort of notice, that is impermissible. That there needs to be some sort of reasonable notice to the client to allow the client to make that informed decision about whether to continue the representation. The opinion looks at Rule 1.5 in particular. Of course, there's always a consideration that a fee cannot be clearly excessive. But presuming the fee is not clearly excessive, there's still the question of whether or not the firm can simply change it. And this is something where our rules, our North Carolina rules, differ from the model rules of professional conduct. The model rules allow a lawyer to impose a reasonable fee increase, just kind of a blanket statement. Our rules, however, have a comment under 1.5 that doesn't exist in the model rules that says that essentially once an agreement has been reached between an attorney and a client, that the attorney can't essentially try to coerce a higher fee by threatening to leave litigation, that even if they've drawn a bad bargain, that's going to be something that essentially the lawyer would have to live with. However, the lawyer still can seek to renegotiate the fee based upon changed circumstances. And that's something that the subcommittee discussed, because the reality is that circumstances do change during the course of the representation. A case that you thought was going to take 3 months ended up taking 3 years. Fees go up, costs go up, so things of that nature. So the opinion essentially outlines what are the parameters for an attorney to impose a fee increase, what sort of notice, and that's what the opinion concludes, that some sort of reasonable notice needs to be provided to the client about the fee increase, what it's going to be. That of course the fee increase cannot result in a clearly excessive fee, but that essentially you have to give that notice, give the client the opportunity to understand the changed circumstances and to either elect to the increased fee and continue with the representation, or perhaps terminate the representation. It also allows the attorney, if they provide that reasonable notice to the client about the fee increase, if the client just refuses to pay, that at that point the lawyer could withdraw from the representation pursuant to Rule 1.16. So you have the opinion in your materials. The subcommittee discussed this and went through a couple of different variations. I thought it was one of those difficult things, trying to figure out how you draft an opinion to cover a multitude of scenarios, including corporate clients and individual clients and so forth. But the subcommittee was satisfied with the draft that's in your materials. That would be my background.
All right. Thanks.
I think the subcommittee did a great job on working with Brian to form this opinion. We met in March and came up with a good amount of changes from the current draft at that point. Brian worked with the opinion to make a more polished draft and circulated that to us by email. We all reviewed it, and additional changes were recommended that were incorporated here. I think the subcommittee did a great job getting a kind of a diverse group of views to make sure that we are doing what Brian said, and making sure this opinion doesn't affect the client that struggled to pay his lawyer, in an individual circumstance, but also fits the circumstance where you have a corporate client. And so there's a lot of different types of clients out there that can be affected by this opinion. And so we landed on this opinion, which we think is a great opinion, that it meets all of our goals. It's our recommendation to publish the opinion and get some comments. For this subcommittee, I did what I should do more often, and I kind of stayed quiet and let the more knowledgeable lawyers that have more experience in this type of billing practice and fee agreements to really give the input that formed this opinion. So I think some of them may have some comments.
Is that a motion to publish?
That will be our motion public. Yes, we have a motion published.
Do I have a second? All right, so I have a motion and a second. Is there any further discussion? I'll hear from subcommittee members first. All right, or anyone, if anybody has any comments or questions? Yes, sir.
Inquiry 4 speaks to the 3% as an example of what is not a really excessive fee. Does this set a benchmark? And how does this help if we're looking at a fee agreement that says it's a 10% increase? How does this opinion answer that question?
Sure. We discussed whether or not we should set a cap on what is or is not clearly excessive. The comment being 3%, is that what's supposed to be kind of acceptable now? And the answer is no. That one was dealing with kind of that particular example, but the opinion tries to stress that the big consideration is whether or not the increase results in a clearly excessive fee. And you could have that example of, you say you have a domestic case that you start off as an associate billing $200 an hour, and you think it's going to take 6 months and it ends up taking 3 years. And by the time you get to year 3, you become partner, you have grown your practice, your reputation, your skill set, and it would not be unreasonable to increase your fee from $200 to $300. Well, my gosh, that's a 50% increase. But that wouldn't be a clearly excessive fee under 1.5 necessarily if you consider the skill set, the time and knowledge, all the different things, the factors that you see there in 1.5A. And so the 3% is not meant to be kind of this is reasonable or unreasonable or anything above 3% is clearly excessive. I think that's where the language of the opinion trying to stress you have to look at the end result. Is the fee that is ultimately being charged to the client as a result of the increase clearly excessive? But it could be, there's a variety of factors that could play in there.
And we tried to stay out of that part of it, and because it's situational, every case is different.
I think the key thing with 3% was that in the fact pattern, it was specified a rate increase can be up to that amount. And since that had been disclosed, that's what made it work.
Yes.
All right. Yes, sir.
Good morning. I don't have a comment about any specific part of it, but I would anticipate, and I'm sure the subcommittee did as well, that this one's probably going to draw a fair amount of comments once it's published, and I think that'll be healthy for vetting this.
Yes, I agree.
Yes.
The 30 days in inquiry number 3, was that just a number that you came up with as a reasonable amount of time for the increase to notify the client of the increase?
Yeah, we drew straws. No, I'm kidding. It was that notion of what constitutes some sort of reasonable notice, and I think that's where some of the subcommittee members offered their own experience, what their practices were, and what's reasonable to give a client the ability to make an informed decision. That's something that I think one aspect that influences my thought process is just the general notion, the general responsibility to communicate with our clients, and like under 1.4b, we have a duty to inform our clients, to let them make informed decisions about their representation. Sometimes that's talked about with regards to strategy and goals and all that, but this is an aspect of representation too. So it is kind of the 30 days is not something that I can say we pulled out of a comment or a particular rule. It was really a discussion of what do we think is reasonable to give clients that opportunity to say, I see this, can I afford it? What are my options? And so we settled on 30 days, but understand that some folks, I think, talked about maybe even giving 60 days. I think that might be unnecessary, but certainly something like, giving folks just a week to make a decision on something as critical as, do I continue my representation with this person, would probably be a little too short. So we settled on 30.
Any other questions, comments from anyone? All right, so yes.
And Brian, I might not have fully understood your response earlier, but do we have to put 3% there? Couldn't it be stated percentage that's not unreasonable, or stated percentage that is deemed to be reasonable, rather than putting the 3 in there, which might cause people to view it as a floor or something or whatever?
Yeah, so for those that didn't hear, the question just whether or not the 3% that's referenced in inquiry number 4 is necessary, or should it be X percent, with the stated percentage. And Nancy, I think you're right. We could just go with maybe a non-numeric number If the 3% is seen as something, if people read that 3% and think the state bar is saying I cannot go beyond 3%, then I think that's good feedback. We don't want that to be confusing because ultimately percentage is really going to be relative. Like we said, if you're charging your folks $100 an hour for some reason and you end up going to 200, that's 100% increase. But that's probably still pretty fair in terms of or maybe not being clearly excessive. So you're right. We don't need the 3%. If the 3% is causing confusion, that would be the opposite of what is intended. So I don't know if anybody has any feedback as to whether or not you think the 3% is actually more confusing than helpful.
Warren?
I like the 3% only to the extent when it juxtaposes to the 20% in the original inquiry. And I would put X. I'm concerned where people might draw the X. They you set up at least a default level of 3% is roughly about inflation most years. This year, but it's roughly about inflation, and so that kind of gives a base level. And if you want to, I think it's pretty clear that that's not the cap here, and that there are other factors than just the percent put in there. Frankly, I don't think it'd be confusing.
Any other comments? We do have yes.
I'm still struggling a little bit with the 30 days. It doesn't seem very long to me. Tell me again how the committee got there. You thought 60 was too long, or?
I mean, I welcome comments from the other subcommittee members. This was just kind of a discussion of what do we think is reasonable under these circumstances. So Lori might have some.
So I served on the subcommittee. We didn't spend so much time talking about the amount of notice as to we spent more time talking about the different types of practices, because some firms, their rates are, they're bigger firms, that they may have corporate clients who set the rates. They may have different partnership levels such that if one rate goes up, the partner rate automatically has to go up to be higher than other rates. So just because there's such a variety of practice areas and clients, we really just had to pick something that looked like that appeared to be reasonable notice. So I don't think the opinion was intended to require that 30 days notice be given in every instance. It's just a reasonable amount of notice, really based on the type of client and practice that you have. So, for example, I do domestic law. If my client had a trial coming up in a week and I said, hey, I'm going to raise my rate $100 more effective before your trial next week, that would probably not be reasonable notice. But in other circumstances, it might be, because it might be the corporate clients dictating the raise, the increase in rates that impact a certain number of the partners. And so there was someone from Wyron Robbins. Yeah, she came and spoke and talked about how her rates work, because it was very different from the way my rates work and Heidi's rates work. And I'm a small firm, she's in a big firm, and so there were just so many different practice areas we had to consider. And then, of course, there's also flat fees that some people charge. So, it was more about the reasonableness. And I think that goes the same for this 3% that we're talking about. That's more about what is reasonable under the circumstances. And I see the concern that maybe 3% is setting some standard. Maybe we need to add a sentence about that, saying this isn't remarking upon whether or not 3% is reasonable, but that paragraph's about the notice
Yeah, and I think Lori's comments are spot on. With regards to the notice, the 30 days was something that I think we could have used these as examples. The 30 days was something that felt like, all right, well, this is a reasonably understandable thing across multiple practice areas, but really the crux of the issue comes it's towards the end of that first paragraph of Opinion 3, where it says that the reasonableness of an amended fee agreement with a client will depend on the context and circumstances of the representation and the attorney-client relationship, as well as a variety of considerations, including but not limited to the sophistication of the client, practice area, and its related customs, and so on and so forth. And so it really is about the reasonableness of notice being dependent upon the circumstances, similar to Opinion 4, when we're talking about the 3%, where there's a kind of like right in the middle of that paragraph, provided the increase in the rate is not clearly excessive, lawyer may increase the billing rate as set forth in the agreement. The agreement, of course, setting forth a 3% increase, and we use 3% as the example. And I believe when I drafted it, Warren, your thought about this is something that seems to be pretty typical, like in the contracts that I know we have signed as an agency with different services. It's like they offer that 3 or 5% increase, whether it's dealing with inflation or whatever. It's just kind of that standard thing. But again, they're just supposed to be examples. It ultimately depends on what's the reasonableness for notice under the circumstances, what percentage of an increase really. It's kind of a neither here nor there. It's a question of, do you end up charging a clearly excessive fee as a result of the increase? That's the end analysis.
Well, on the other part is, remember, the engagement letter has already forecasted the fact
Yes.
that there is the opportunity and potential for this increase. So when you then give them 30 days, I think you're saying, all right, sort of pursuant to our contract, this is what we're going to do. So I think we all felt like, considering it had already been laid out on the front end, we hope anyway, we give engagement letters that 30 days notice that, okay, this is going to happen, was within bounds of, clients who actually read what they're signing.
But I guess I want to ask Fran pointing out the 30-day thing. 30 days, just like the 3%, if that's tripping up the reading of the opinion, because it seems like the bar is setting an official standard, that's not the intent. The intent is to look at the reasonableness of the notice, as well as whether or not the increase results in a clearly excessive fee. So if that's something that we need to emphasize more, perhaps by including a sentence, like Lori had said in Opinion 4, that says, this, to be clear, this opinion does not state that 3% is the only permissible increase. And then, that ultimately it's the increase is supposed to be something that does not result in a clearly excessive fee. That is not a material substantive change from the opinion, and I feel like if that's the will of the subcommittee or the committee, then I don't love drafting in committee, but I feel quite confident that we could add a sentence there that reflects this perspective, if that's what everybody would like.
Do you think that that's necessary though, when these are just in here as a part of the question? It's just examples.
It's an inquiry.
Right, it's an inquiry. It's not the opinion itself, but I mean, yes.
Well, I think what I'm hearing is there's definitely a possibility of perception that the bar is setting a standard or a baseline. So I think that's probably going to be one of the comments you get back multiple times. Is there tension with that perception and anti-competition principles? I know the clearly excessive standard is there and it's an inherent part of our rules, but it strikes me that if the bar is perceived as setting, here's where your rates can increase, that's going to touch on some anti-competition.
I do not claim to be an expert in
antitrust. It just feels that way.
I think, well, and I guess that's the notion of a clearly excessive fee. I mean, if somebody wants to increase their rate from $100 to $2,000 an hour, would we consider that, if somebody filed a grievance for that, would grievance see that as clearly excessive? I think they'd have to go through the analysis under 1.5A to determine if that is clearly excessive. If it is, then that subjects the person to professional discipline. Is that anti-competitive? I don't know, but I guess we've never had 1.5 challenged in that regard. I don't know that that notion, but it would come under the clearly excessive. So that's where I hear the potential for confusion based upon the examples that are in here, and that's one of those where sometimes it's good to get that feedback because I'm in this world of drafting. I know what we're intending. The subcommittee knows what we're intending, but as fresh eyes, you may see it slightly differently. So perhaps it is, I don't know, I guess I'll look for the committee's direction if y'all think that it would be better to have some clarifying language in both of those opinions to stress that the numbers, the examples used in these inquiries are not intended to be, I guess, the baseline default or anything like that.
Do we really think that lawyers read these and not read them as they are, as inquiries? These are examples that have been submitted with questions, and the opinions are answering this based on, it says clearly, under these facts. Like, do we, or is it that because we all are reading these so much, now we're reading more, so we have a motion and a second to publish, so do we want, we can continue the discussion, but we know that we will also get some comments and, from people when this opinion is published this way, but is there some thought that we should look to sending this back and drafting it a little more? Because I seem to think that we're lawyers and people should be able to, so I say this phrase all the time. My friends pick on me about it. And I say, read for understanding, listen for understanding. So I think it's pretty clear under these facts, but maybe I'm thinking.
I agree with you.
Yeah, okay.
I think lawyers are going to cling to that 3% in 30 days. They're looking for specifics from the state board, and that's what they're going to hone in on.
But if the opinion itself is not saying, you must give 30 days or you must do 3%. It doesn't state it in that way. But do you think that even without that, rhetorical question, of course.
I've never had fees, I work in the government, but for me as a reader, it was just a helpful illustration.
Right.
I did not read it
Right.
to say, it gave me an understanding of what excessive might be or what reasonable could be. And that seems to be the purpose of the comment period, is for people to weigh in on that. I didn't take it as a hard and fast rule at all.
Yes, and then I'll come over. Yes.
I think that's probably right. I think Brian's antenna are up on a good point, though. I can see situations, think about it from an evidentiary standpoint, if you're trying a case and get somebody's, well, the state bar says, la-di-da, and even though you introduce that as evidence that might try to be persuasive to the court, got a lot of judges sitting around here, that this is just some evidence. It might just be some evidence to the court, but the jury may hear that 3% or that 30 days, and that's the imprimatur that comes from the state bar. I think a little clarifying language that there are, and I don't know, but Brian, you're real good at weasel words, examples. But, I mean, so the Heidi Roy situation, if you had a client letter that said, I'm going up on the week before trial, my fee goes up X effective today, and we got trial next week, by the way. You really damage the public. They don't have the option that they've got to exceed the coercion. And I do think there are examples where. And that could also be true in a 30-day situation. We're going to trial in 30 days, and for potential order trial, I got my rates here about double. And that the replacement cost of you is you can't do that. The client can't do that, so they have no option. I think just some Weasley words might be good. We're going to get comment off you're right. So we postpone this, but it's coming. We're going to have to deal with this at some point.
Maybe a footnote.
So the suggested.
Or a one, they put at the bottom, these are not intended.
Read these as examples.
Can I make a motion to strike David's description of me as
Yes, sir.
First, I appreciate the work being done because these are the type of cases or issues that trying to turn around the agency and business on their things. I personally, before I got in this committee, didn't really understand how opinions are different. When I'm in court arguing about a cause motion and I see a case that says odor of alcohol, recreational slur of speech, it sets a standard. And using expressio unius as exclusive arterias, meaning especially one thing is better than another, lawyers are going to read this, in my humble opinion, and say, that's the benchmark, that's the console. And so, but I don't want to sit back committee, I would just use free drafting phraseology.
Oh.
Thank you. I appreciate that.
These are just examples that we're not setting a benchmark or something like that. I personally, we get used to hearing what Brian said, but it makes total sense. Before I got in this room, I was like, oh, okay, that's the number.
Yeah, I think this, to me, I feel like we have two options. One is to publish as is, knowing that we're going to get comment on this, and we could still make those changes even after publication. If that's the only change, that does not substantively change the opinion that would require republication. Or if you all think that's a really good idea right now, this is the thing that I cannot present you with the thing that you are publishing right now because I need to draft the rodent-esque language. But still, I feel confident that I'm hearing the sentiment here, and I think that it can be easily put in there. So I guess my question is, what's the will of the committee?
So right now we have a motion and a second to publish as is.
I think we vote on it.
So, exactly, we have to vote on it.
Yeah.
So, we have a motion and a second to publish this opinion as written. All those in favor, please say aye.
Aye.
Any opposed, nay?
Nay.
Okay. I think I heard two.
Yeah.
All right, so the motion passes to publish, and so we will get those comments and we'll take that, and we're ready and armed with what we need to do when necessary. All right. Thank y'all. That was good discussion. Reconsideration of published opinion. Proposed 2025 formal ethics opinion 1. Obligations related to notice when lawyer leaves a firm. Suzanne.
Yeah, I don't know where the microphone went, but this is the opinion that talks about the requirements, the notice requirements when a lawyer leaves a firm, and talks about which clients have to be notified that the lawyer's leaving, or what has to be included in the notice. And it was a pretty lengthy opinion. It has 8 inquiries, and I was really surprised that we only got one comment, because there's a lot of information in this opinion, and we only got one comment, and that's from an attorney named Letha McDowell. And her issue is she feels like she wants the opinion to require the law firm and the departing lawyer to have to give notice to all of the departing lawyer's former clients. And I don't think that that's what we want anybody to be required to do. And we also have another ethics opinion already, 2021 FEO 6, which is the departing lawyer's email requirements, and it kind of talks about what a law firm is required to do when, as far as the departing lawyer's email and giving the departing lawyer's information when somebody calls. And so that's kind of touched on in that opinion already. And also, there's nothing that prevents the departing lawyer from contacting these lawyers on his own. I mean, this lawyer is perfectly free to. The opinion requires the law firm to give the departing lawyer a list of all his former clients, which we had a little bit of struggle even requiring that. But once that lawyer gets that list, that lawyer's free to contact all of his former lawyers who wants to get into that trouble. But I don't think that anybody wants to put that as an additional requirement on a law firm when an associate leaves, that they have to give notice to all that associates' former clients. And that's the only comment that we got.
All right, Craig.
Well, I guess Suzanne and I talked about it. We thought it would be a good idea to communicate directly with the person who raised the issue, and that's what we're going to do.
And I did. I sent her an email and said, have you seen this other opinion, and what are your thoughts on that? And she's actually on vacation for a couple of weeks, so I haven't heard back from her. But regardless of whether that satisfies her or not. The issue before you is whether you think we need to make any addition to the opinion based on a comment we received.
Do you have any other comments or?
Brian, you mentioned one other comment that really isn't substantive, but I thought it'd be.
Oh yeah, I did get some more feedback. One of our past presidents, Colin Willoughby, texted me after he read that, proving that some people do read the opinions in the journal, and said, just read the opinion. Y'all did a really good job on a tough issue. So kudos to the subcommittee, Suzanne, for drafting that. But Colin Willoughby thinks it's good.
So at
this point, we don't recommend doing anything that revises the substance of the published opinion, and I guess we're lucky enough to have the person from whom this inquiry emanated, Warren Savage, here, and for to quote the little John Lennon. I'd like to say thank you on behalf of the group and ourselves, and I hope we can pass the audition.
Don't be such stupid.
Anyone else? Right. Yes. Anybody else want to make any comments, questions? Do I have a motion to send to council for adoption? Second. And I have a motion and a second to send to a full council for adoption. All those in favor, please say aye.
Aye.
Any opposed, say nay. All right. That was a lot of work on that one. Thank y'all. All right, we have new inquiry. Inquiry of the staff, client referral to law partners business. Ryan.
All right, so this is the new inquiry for the quarter. This is based upon a number of inquiries that we have received both recently and over the years. I've already heard from some committee members that asked me kind of the straightforward question that some of you all may be having. Have we already addressed this in all these other opinions? Because we've addressed this question of lawyers and the relationship with title companies and so forth, and the answer is not exactly. This particular scenario that's come up and been presented to us for advice really deals with a situation where you've got an attorney that's conducting a real estate closing, and their partner, someone else in their law firm, owns or has some sort of ownership interest in a title insurance company. So the closing attorney is not the one that has the financial interest in the title company. They are just doing the closing, but they want to refer their clients to their partner's title business and just kind of send that business over to the partner while they conduct the closing. The question, of course, was whether or not that presents a conflict of interest and whether or not the closing attorney can actually send that business over to their partner. Or the partner's financial interest in that title company creates a conflict that gets imputed to the other law firm members, including that closing attorney. I guess maybe debate that comes around here is that in some ways I think that's been previously viewed as, well, that's a personal interest conflict that the owning partner has, and that personal interest conflict does not get imputed to other firm members. That's something under Rule 1.10, that personal interest conflicts, such as whether you're talking about a spousal connection with opposing counsel or whatever it might be, personal interest conflicts do not get imputed to other members and conflict out those other firm members. But in this particular scenario, you have those questions of, all right, well, you've got, let's say the two lawyers at issue are both partners. Partner A is doing the closing and sends business over to partner B. There's no direct financial interest necessarily to partner A, but is there some sort of concern about maybe self-dealing or anything like that, just helping out your partner who you do have a financial connection to? Or if partner A maybe is not really partner A, maybe we say it's associate A and is sending business to partner B, or partner B's title insurance company, is that appropriate? Is associate A truly exercising independent professional judgment, or is associate A trying to keep partner B happy in hopes that associate A will become partner A? So it's a tweak on a question that we have seen before, but in this situation, we're looking at the imputation of conflict based upon the ownership interest in title companies. I did not draft an opinion for this particular inquiry because there's a lot of different and strong opinions on both sides of this issue. Our draft opinions are purely drafts. They are starting points. My fear, quite frankly, was drafting an opinion that reaches some conclusion, is going to cause a bunch of chaos, and maybe tick a lot of people off, even though it's purely just a draft. So there's no draft opinion. This is something that I know has been at issue before in the grievance committee. It's been at issue with ethics advice, and I think there's different approaches for what we've historically looked at in North Carolina versus what other states are doing as well. So that's where the recommendation from staff is to send this to subcommittee for study, so we can figure out exactly what the answer should be if the bar needs to issue an opinion on this particular matter, first of all, but then to see what the answer should be and go through that process at that point. That's it. That's my presentation.
All right, Judge Langen, as you all see your names in parentheses, those are our proposed subcommittee members, and it goes to subcommittee, so any thoughts?
Thank you, Madam Chair. Brian, I walked away from reading these materials with the impression that we've answered this question. There is some nuance, but I don't know that my analysis will change very much. I think there is a taint of self-dealing. Exactly what it be 1.10 or 1.11, but somewhere along the line, I think this is going to look bad. I am curious, however, if South Carolina or some other jurisdiction is allowing it, what was their thought process? How did they reconcile that with their rules? Did they change a rule? Did they make an exception? And I'd like to know where they came at it.
All right. Thank you, sir. Any of the other two proposed subcommittee members would like to be heard? Any kind of gut reaction, thoughts?
Crawford Cleveland, District 35 Bar Counselor. I agree with Judge Langen. I think it creates an appearance of conflict. My gut reaction. Good subcommittee to me.
Will be heard? Any?
Julia Ambrose.
Yes.
I'm with Brooke Pierce. With my first look at this issue, my initial instinct is to
And here.
You kind of faded out at the end.
Oh,
Your gut
sorry.
instinct
Yes,
was?
I agree.
Okay.
As an initial matter.
Can we add a real estate lawyer to this?
Yes. Yeah, we're definitely going to. I think that's, to be clear, when we designate folks to opine on these things at first, this is kind of this is that going back to school and saying you're on notice, you're going to get called on.
Right.
If you have no interest in serving on the subcommittee, please let me know. If you have interest in serving on the subcommittee, please let me know. But we definitely need to get feedback from the real property section. I know we have a lot of guests here that have a lot of interest in this. I don't know where everybody sits on this this particular issue, but I have a feeling there are some strong opinions in this room. Now may not be the time to actually start discussing all that, but that's going to be for subcommittee. But yes, we do need to get a variety of perspectives here, and we do have a dirt lawyer.
I mentioned to Brian last night I'd be happy to help. Vineyard and Riverside Soil, and there are nuances. Like in South Carolina, law firms are in the title company. So there are things that need to get vetted. I think that the issue doesn't smell good in many respects, as many of you have pointed out, and I think we need to address those things.
All right. Any other discussion? Do we have a motion to send this to subcommittee? Okay, I have a motion. Do I have a second? Motion and a second to send this to subcommittee. All those in favor, please say aye. Aye. Any opposed? All right, subcommittee it is.
And can I just also add to our guests in the room? All of our subcommittee meetings are open. They will be streamed on YouTube. at some point, this is one of those delicate processes where, frankly, sometimes you have too many cooks in the kitchen. The subcommittee needs to have an initial discussion, but at some point we do need to get feedback. So if you are interested in receiving any sort of notice about when the next meeting is going to occur, please contact me, and we'll be sure. We post all of our meetings on the website, on the State Bar's website. We stream them on the State Bar's YouTube page, just like we're streaming today's meeting. But if you want that sort of notice, please do let me know, and we'll be sure that you have access to all that stuff. This is something that we need everyone's participation in to make sure we get the right result.
Yes. Thank you for saying that, Brian, because I want to make sure that everyone knows that we love to get feedback. I know it's a notion out there that we do this kind of stuff in secret at the State Bar and nobody knows what we really do, but we really do want to hear from our members, and even people of the public as well. So thank you all for being here. Do as Brian said, let him know if you would like to get notice of those meetings. You all have a good rest of your day. We don't have any ethics advisory.
Nope.
No, nothing. Right, we're done. We got through this agenda. 1 hour. Y'all enjoy your other meetings.
Thank you.